or the entity of the Killeen Police Department does not change the aspect of the other organizations in the area, which would be the Sheriff's Department, DPS, or anyone else who assists us on a regular basis doing those kind of high crime details to prevent or find some of those individuals are violent felons and things like that. They would be more reluctant to come to this area and assist with those things if this existed and continued to pass. Finally, the last aspect of this that I would like to bring up is just the fact that we are here as an organization. I'm not here as an officer, and we are here for our officers and will continue to represent them moving forward. We have worked well with the city in the past through our contract negotiations and things like that, and we continue to do so moving forward regardless. So,
thank you.
thank you.
County Commissioner Bobby Whitson. Good evening, sir. You have 4 minutes.
Madam Mayor, City Council, appreciate the opportunity to speak on this issue. I've been watching it from afar, from a county level, because this really doesn't affect what we do at that level until now. And I've had the opportunity and the blessing to be able to be in the middle of a lot of the discussions that I feel like I'm pretty well informed on the issue. I've talked to many of you on the issue, many of my folks in Harker Heights as well. That's also in my precinct. And unfortunately had the opportunity to talk to a lot of folks outside of these two cities that already have opinions of Killeen and or Harker Heights. And I do not envy the position that y'all are in, from someone who sits in a very similar position of yours at the county level, knowing the decision that you have to make and knowing that every decision you make is going to make some people happy and some people not so happy. I want you to understand that that's your job, and that's going to happen either way you go tonight. And I want citizens of Killeen here to understand that as well, that y'all are going to vote and you are going to make a choice, or you may not vote at all, which is a choice, to either leave this on the books as is, amend, or rescind this. Many good points have been made about the legalities. Many good points have been made on the other side about why this is something that could potentially benefit citizens here. And I can't honestly say that I disagree with any of them, quite honestly. There are different perspectives on every issue. But ultimately, as a city council member, you are going to make a decision that is going to impact your city. Either way you go, there are already people talking about recall elections. There are already people talking about filing lawsuits. No matter what decision you make, that's a risk that you're taking right now. I would encourage you to look at being on the side of right. And what is right? Well, if you're going to have a recall election, that can happen for lots of things for any reason. And quite honestly, that's up to the citizens, and there's nothing you can do about it. You can make your decisions and do the best job that you can do, which is your responsibility, and somebody's still not going to like it, and they may try to recall one or all of you. Please don't let fear make your decision tonight on any kind of a recall stance. On the litigation side, you are putting Killeen on the map. Killeen's already on the map, again, whether you like it or not. Depending upon the situation or the decisions that you make now, there are litigants on both sides that are talking about fighting this. If you have to go to court in the state of Texas and defend your position, do you want to be on the state side or not? And I think that's the position you need to look at when you make decisions for the city of Killeen. And for, when I say the city of Killeen, I'm talking about the residents. I would not in any way, shape, or form, and I don't think any of you are, I've talked to most of you, I don't think any of you are disregarding the voters. I don't think any one of you are disregarding the law. I don't think any one of you have ill intent on any of this. You're just caught in a bad spot. And the decision you make tonight needs to be based on what is best overall for your citizens. Maybe it's against their wishes as voters. Maybe it's not. Maybe it's against state law. Maybe it's not. But you're going to have to defend your position regardless of what decision you make tonight. And I would encourage you to be on the right side of the state. The state gives you the charter that you have that makes this the city of Killeen. The state dictates what laws you can and cannot live by when it comes to the decisions you make in this city. And so if litigation occurs, and I think it will either way you go, from at least what I'm hearing, you want to be on the state side because it's going to be heard in a state court with a state attorney. And I wouldn't want to be on bad footing if I were you in that position.
Sir, thank you. Your time
Thank you.
is up. Madam Secretary, the ordinance and resolutions.
OR 22-021, consider an ordinance canvassing the returns of the November 8th, 2022 special election. The caption of the ordinance reads, an ordinance by the City Council of the City of Killeen, Texas, canvassing returns and declaring the results of a special election held November 8th, 2022 for a proposition to eliminate enforcement of low-level marijuana offenses in the City of Killeen.
Thank you. Mayor Pro Tem.
Section 1, there came on to be considered the returns of an election held on the 8th day of November 2022 for the purpose of consideration of a proposition to eliminate enforcement of low-level marijuana offenses in the City of Killeen, and in appearing from the returns duly legally made that 24,310 voters cast ballots at the election. That the proposition received the following votes. Proposition A, shall an initiative ordinance be approved to eliminate enforcement of low-level marijuana offenses in the City of Killeen to include the following. Prohibit Killeen police officers from issuing citations or making arrests for Class A or B misdemeanors, possession of marijuana offenses, except in limited circumstances. Prohibit Class C citations for drug paraphernalia in lieu of a possession of marijuana charge. Prohibit the use of city funds or personnel to perform testing to confirm whether a substance meets the legal definition of marijuana except in limited circumstances. Prohibit Killeen police officers from considering the odor of marijuana or hemp to constitute probable cause for any search or seizure except in limited circumstances. Require the Killeen police officers, require that Killeen police officers receive training on the ordinance. Require that the police and procedures be updated in accordance with the ordinance. Require regular open meetings with stakeholders to discuss practices related to the ordinance. Provide that a violation of the ordinance may subject a Killeen police officer to discipline and require a report within 3 months of adoption of the ordinance and annually thereafter to be submitted to the City Council concerning implementation of the ordinance. 16,886 votes total for. 7,424 votes total received against. Section 2, that the election was duly called, that notice of the election was given in accordance with the law, and that the election was held in accordance with the law. Section 3, that Proposition A was approved by the voters of the City of Killeen and is hereby adopted. Section 5, that the ordinance shall be effective upon its passage and approval according to law. I move to approve OR 22-021.
We have a motion. Is there a second to the motion? Please raise your hand. Is there a second to the motion? A motion fails.
Yeah.
You have to raise your hand.
Oh,
You want to do it again? You can do it again. Just
I
make the motion.
I move to approve OR 22-021.
We have a motion to approve OR-22-021. And there's a second by Councilmember Adams. Any discussion? Can you hear us, Councilmember Sagara? Thank you, sir. If you have to raise your hands going forward, you have to raise your hand. This is just to approve the canvases of the votes. Yes.
I think you said what, so that everyone understands that we are only approving the
I
canvas.
just said that. Yes,
Okay,
sir.
thank you.
Thank you. All in favor, yes. All opposed, no.
So pushing or raising?
We have to raise your hands. Everything moving forward. All in favor, yes. Raise your hand. 1, 2, 3, 4, 5, 6. 6-0 in canvassing the votes. Madam Secretary.
RS-22-165. Consider options regarding Proposition A and the initiative ordinance to eliminate low-level marijuana enforcement and discuss any council member concerns about Proposition A.
Thank you. City Attorney Clemens.
Good evening, Mayor and City Council.
Good evening.
This is an item to consider your options with regard to the initiative ordinance. And I have a presentation just to go through the background and a refresher on the ordinance provisions itself before we go through options. Okay, looks like you have it. All right. So a little bit of background. On May 25th, an initiative petition to eliminate low-level marijuana enforcement was filed with the city secretary's office. And council was required to place the exact language as proposed on the ballot unless the council passed the ordinance exactly as it was proposed. The charter does not, this question has come up, the charter does not have a process to disallow an initiative petition if in its opinion it violates state or federal law. There is a provision where prerequisites, if there were prerequisites that could not be met pursuant to state or federal law, did not comply with the process. I can give an example of that if we need to, but it is my opinion that the charter required us to have an election because council did not pass the ordinance as it was proposed. And so we did have an election on November 8th, and the majority of electors voted in favor of the ordinance. State law requires that the election be canvassed, which you've just done, and once the election is canvassed, the initiative ordinance is an ordinance of the city of Killeen. All right, so I want to go through the ordinance provisions with you just as a refresher. So the first section says that Killeen police officers shall not issue citations or make arrests for Class A or B misdemeanor possession of marijuana, with certain exceptions. And just to be clear, that is a prohibition with regard to Killeen police officers only. It doesn't make enforcement in the city illegal by other law enforcement, but Killeen police officers shall not issue the citations or make arrest. Class C citations for drug paraphernalia shall not be issued in lieu of a possession of marijuana charge. No city funds or personnel shall be used to perform testing to confirm whether a substance meets the legal definition of marijuana. The odor of marijuana should not constitute probable cause for any search or seizure except in limited circumstances. And officers shall be trained on the ordinance. Policies and procedures shall be updated in accordance with the ordinance, and regular meetings with stakeholders shall be arranged to discuss practices related to the ordinance. Violation of the ordinance may subject a police officer to discipline. This is not a requirement of the ordinance. It does not require discipline. And I do have an opinion that disciplining an officer while complying with state law would be problematic and would subject the city to legal challenge. Within 3 months of adoption of the ordinance and annually thereafter, a report shall be submitted to the City Council concerning implementation of the ordinance. So before we discuss your options, I want to go over specific state law that impacts this ordinance. It's already been mentioned a couple times here during the citizen comments, but this is section 370.003 of the Texas Local Government Code. And this provision states that a governing body of a municipality or a police department may not adopt a policy under which the entity will not fully enforce laws relating to drugs, and that includes Chapter 481 of the Health and Safety Code, and that's where the possession of marijuana laws are found. So I believe that the initiative ordinance would likely be found in violation of this statute because eliminating misdemeanor marijuana enforcement is not fully enforcing the possession of marijuana laws. Before I go into the alternatives, I just also wanted to state, I'll go back, there are a number of other federal and state laws implicated, but this is perhaps the most direct. And because of this law and others, there could be legal challenges, and you've heard tonight that they could come from all sides. This could include lawsuits, injunctions, actions for disciplining an officer. And there are also practical concerns I wanted to mention, but the police department may be more qualified to discuss those practical concerns, but such as some of the things you've heard tonight regarding prohibiting odor of marijuana being used as probable cause, or the testing of marijuana. Those are some practical concerns the police department would have to deal with. And if you have questions about that, I know the chief is here and available to answer those questions for you. So the alternatives, though, that you have tonight are to amend the ordinance, 1, to repeal the ordinance, or 3, do not amend or repeal the ordinance. And so I can discuss in more detail what each of these options would look like, but I want to give you an opportunity to discuss and ask any questions you may have.
Would you please discuss each one of them, how it would look like if they make those decisions, please?
Okay. So amending the ordinance, staff would definitely need guidance on what you wanted to be amended in the ordinance. So what your goal there would be, because as I've stated, I believe that it would be difficult to say that you're fully enforcing the statute while also eliminating enforcement of misdemeanor marijuana, and that's the main section. That's the first section in the ordinance. So if you wanted to get rid of that conflict, of that potential conflict between state law and the ordinance, then removing that section. But that is frustrated that, I mean, the will of the voters, that is clearly the main point of this ordinance, to eliminate the enforcement of misdemeanor marijuana. So if you take that out, you're kind of gutting the ordinance. So if your goal was to comply with Local Government Code 370 and not have any conflict at all, not have that be an issue, then amending the ordinance to that nature would be pretty difficult. If your goal to amend the ordinance is to not specifically address that concern so much as the practical concerns, we can go through each section of the ordinance and say, okay, we want to keep this, we don't want to keep this because this doesn't make sense, this doesn't work for the police department. Things like we've mentioned, like the odor of marijuana, the testing, the discipline of officers, if you wanted to try to look at removing those or amending those. So that's what amending the ordinance would look like. I would need guidance from council to say what you want that amended ordinance to look like, and we could bring that back to you for you to consider. Repealing the ordinance would be direction from council that you wanted to repeal the ordinance. Staff would bring back an ordinance to repeal this ordinance. And then your third option of not amending or repealing, you would not need to take any action if you wanted to not repeal or amend the ordinance.
Thank you. Chief Campbell, could you please come up so they can get all the information, and I'm opening it up for discussion to the council. Yes. Chief, would you hold, Mayor Pro Tem would like to speak?
Yeah, I think it's necessary to hear from the chief and the police department as far as the effects of this ordinance on our police department. However, I don't think that this is something that we're going to be able to determine tonight at any event. So I would be leery of repealing it right now, because if it's put up for repeal without the adequate information that we need to go forward with a decision, we're not bringing it. We can't bring it back up for, what is it, 6 months? 6 months. So I would like to. I would like to.
Would like to interrupt you.
I'm sorry?
Go ahead, he'll let you finish because he had a comment.
Okay. I would like to hear what our subject matter experts would have to say about this in the realm of how it affects our police department. Now, as it concerns with the Henry Garza and all the other opinions that we've had out there, because that's exactly what they are, they're opinions. They're not judges. The people who interpret the state law are judges. And any attorney or anybody else that has an opinion, including myself, is just an opinion. But I'm a representative first. I'm not a lawyer at any event. So as a representative, I represent our people, not our state. So if I have to go on one side, either the state or the people, my job is the people. So with that, I would like to take into consideration what the experts have to say in this and make an ordinance that makes sense for us. But I'm willing to listen to what you have to say. But if it's in that, I don't think we're going to come to any agreement tonight,
Okay.
in my opinion.
Thank you. Any other council members like to speak before Mr. Cagle speak? Okay, Mr. Cagle.
Mayor and council, I just wanted to say, while there are lots of opinions, we ought to at least get out there what's not in dispute. You followed the charter. That's our Constitution, and the state of Texas didn't write that Constitution. It was approved by Killeen voters and amended over time, and it's our Constitution, and you did exactly what you were supposed to do. And tonight, all you did was certify the results of the election. You did not adopt a law. The voters of Killeen adopted this law. And now, as one of the speakers said, we're in a mess because we have two laws you've been told to uphold. And so you've heard a lot of information on that, but I would hope that at least everybody in the crowd could understand you've done everything that you were supposed to do up to this point. You followed your Constitution, and now we have to decide. You have to decide where we move on from here.
Thank you, Mr. Cagle. Chief Campbell. Good evening, sir.
Good evening, Madam Mayor and Council.
City Attorney Clemens was talking about the practical, how this will affect, I'm assuming, the police department, and you had a representative from the union to also speak on the concerns about officers leaving, and they want to enforce the law from a state perspective. Can you give us, elaborate some more on this, please?
Sure, some of this will be based on my opinion, on my experience. But I will say that there were points that were brought up that do raise concerns with me after talking with our legal advisor, particularly when it comes to search and seizure. The U.S. Constitution, under some bright line cases, have granted law enforcement officers the ability to search and seize illegal substances based on probable cause, and that probable cause being the odor of burnt marijuana, which many police officers here have the ability to detect that. And to take that away from us and try to comply with the ordinance would be very difficult at best, because we can't, based on our training and experience and the odor of marijuana, we don't know what the weight is. And this ordinance has a weight attached to it, I believe 4 ounces or less. So that would be problematic at best. I really have a problem with the point where you have to discipline an officer when that officer is trying to carry out the duties of the oath that he or she was sworn to uphold, the state law. But we do know that also, as Mr. Cagle just as talked about, we do have a responsibility to the voters of the city of Killeen also. Giving that direction for you from council, having everything that could be in contrast, could be problematic, and to hold an officer to potentially discipline an officer for he or she to lose their livelihood is not fair. So I think any provision where it comes to discipline an officer should be considered also. The fact that officers leave departments for many reasons. They have their personal reasons. I think as you look throughout the country, places like the state of Washington and Colorado, city of Chicago, city of Seattle, city of New York City, and even places here in Texas where the enforcement of marijuana is not a high priority, should be something that should be taken into consideration. We do that now. We use a great deal of discretion in enforcing marijuana laws. And taking away that discretion with you must do this and must do that, it will hamper police work. So now, will we adjust? Absolutely. We've adjusted since the election. there was a little bit of confusion, so we halted our operations when it comes to enforcement, and we look forward to any guidance that the council may give us, along with our legal advisor.
All right, thank you, Chief.
Yes,
Any
ma'am.
questions from Chief Kimball? Yes, ma'am.
Thank you, Chief. I just have a couple of quick questions. So as we heard today, there might be some, it sounds like, obviously some unintended consequences based on these conflicts that were brought to our attention today regarding this. So when it comes to the prohibition from making arrests on the local level, it was mentioned by someone in the audience that there could still be a challenge on the county side, or how would that work as far as the conflict that
Sure.
comes up in that respect?
Based on the ordinance as written and was canvassed and could be adopted as written today, that does not prohibit other law enforcement agencies from conducting operations in Killeen. There's multiple jurisdictions that have authority in the city of Killeen: the constable's office, the sheriff's office, other county officials, even federal officers. So there's still a possibility, if you are a resident of Killeen, just because a city of Killeen as the ordinance that stands now, if a city of Killeen officer confronts you, another law enforcement agency could confront you, and you can still be charged under Texas state law. There's a possibility that the county attorney's office, or maybe the district attorney's office, can review our reports, even though we didn't take a person into custody, but there's still a report that's generated. That person can still be subject to arrest if the county attorney feels that he wants to indict that person or charge that person based on their possession.
Okay. And so based on what we've heard from our attorney and some of the information that was also mentioned today, if we were to try to amend this so that we're maybe not in conflict with the state and the federal law, making those changes would gut the ordinance and then make it irrelevant virtually. My question is, though, I also heard you say that we're already doing this. We're already not enforcing at certain levels, or we're using officer discretion. So can you tell me what the difference would be between this ordinance versus a internal policy?
Sure. When we have an ordinance and you have words like shall and may, our officers are going to try their best we're going to abide by that. But the law, under certain circumstances, under certain misdemeanors, Class C, gives us the officer to a bit of discretion in their work. And Killeen police officers do a very good job now of using their discretion when enforcing Class C violations, speeding, for example. We don't say if you are going absolutely 52 miles an hour in the 50-mile-an-hour zone, we will write you a ticket. No, we use discretion. Now, will some people need to have a ticket? Yes. Can you give a warning? Is there other options? And taking away options from us, because we know that there's a scale of people that we deal with when you still deal with criminality. There's that first-time offender that may need some discretion used on them. And then there may be that person who is constantly in the drug trade. They traffic in drugs, and they traffic in weapons, and they're armed robbers. They break into people's property. They're the ones that's going around at nighttime breaking in cars. And if you find them with some marijuana, well, then they may need to go to jail, because there's a scale of criminality that we deal with. And taking that discretion away will hamper police operations.
Come back. Thank you.
Thank you. Chief, you made a statement that you halt on procedures. Is this, and what did you mean by that?
Sure.
Is that the memo that went out, or what?
Yes, ma'am. Just to clarify, on the date of the election, when the voters approved the ordinance as it was written at almost 70%, there was a little bit of confusion in the way we should do work. Our officers were like, "Hey, Chief, what are we doing now? Are we abiding by the ordinance that passed? Are we not abiding?" We heard other municipalities are doing some things. I said, "Well, listen, I'm gonna put out a memo as a stopgap measure. Let's halt the operation of low-level marijuana until there's some clarification on that." So the memo is out. It's a special order. Special orders come out because we use special orders to temporarily deal with an issue until they become a general order. So I have a special order that we're gonna, and it looks just like the ordinance that's presented to right now, where we're gonna halt the enforcement of low-level marijuana until there's some clarification on that, and then we'll adjust accordingly.
Okay. Any more questions for Chief Kimball? Councilwoman Cobb? You have a question for Chief? Mayor Pro Tem?
What would it look like? And this is not a question for you, but it deals with the police agency being the primary department that's impacted by this ordinance. Seeing as the ordinance has every 3 months or 3 months following and then a yearly afterwards, why don't we compile, because I wasn't prepared tonight to discuss with the police about coming up with a hard-driven ordinance or change to amendment or rescinding an ordinance tonight based off of anything that you say right now.
Mm-hmm.
This takes time, this takes evolution, because we're in the deep end. So now we have to work out what is best. I am not in favor of rescission of the will of the people, because as I stated before, as a representative of the people, that would be irresponsible on my part. However, to make it applicable and make it practical to our city, I think that's what we needed, the nuances of what needs to happen here. We're gonna take more time than we probably have tonight to get to that. So with that, I would like to make a motion of direction.
You can't make a motion of direction until all council members have spoken and Councilmember Cobb's have a comment.
It's not true, Mayor. I can make a motion of direction at any time. I can make it as soon as I start speaking.
Go ahead on. Mr.
So I'd like to make a motion of direction that we set aside 3 months out from today to be able to take this information in and give some good, complete directions as far as an amendment, or if rescinding needs to happen at that time.
So let me get some clarity. With this motion of direction, the ordinance will stay as is, and we would take 3 months to work with the city staff and the police and whomever to, if we want to modify it.
Yes, because we have to come back in 3 months anyway, unless it's rescinded tonight.
No. Ms. Clemens, before we move forward, can you clarify, do you understand what he's saying?
I believe he's referencing in the ordinance, section 2286, that says within 3 months of adoption of the ordinance, the city manager shall present to council a report concerning implementation of the ordinance. And so I believe that's what Mayor Pro Tem is referencing. And
Yes, that's correct.
Right. So my question, can we get a second to that so we can go into discussion if someone's going to say? Okay, Councilwoman Gonzalez second the motion of direction. So I just want to get clarity. So the police department, everyone in here understand that we're going to come back in 3 months, but the ordinance as is, and the citizens need to know this too, it is in effect as is. Is that correct?
that's my understanding of the motion.
It's been in effect since we canvassed it.
Well, no, it's
Mayor?
when you got to vote on it. You had to vote on it, the canvas, the vote. Then it becomes in effect. Am I correct?
Well, that's what I said. I mean, you canvassed it earlier today, and so once the, yes.
Okay. Are you, anyone else? I'm just trying to get, sir, I'm just trying to get clarity first before we move on. So.
Mayor,
Yes, sir.
can I talk?
Councilwoman Cobb is before you. Councilwoman Cobb,
Good
I'll
evening.
come back to you with the clarity.
Good evening, Mayor, council members, and our guests tonight. I'm good with quotes, and there's one quote that stands out tonight. It says, "Our lives begin to end the day we become silent about things that matter." The vote is the most powerful tool that a citizen or a constituent will ever have. It helps us when we're right. It helps us when we're wrong. As a public servant, I spoke to Mr. Bass before we had a little session together, and he was telling me all the reasons why we should vote for Proposition A. He had some excellent facts, but I still said no. Tonight, I have to still say no, But I want you to listen to what I have to tell you. You voted the desires and the wishes of how you see the city of Killeen with Proposition A. We're faced tonight with the law. I took an oath of office, and it said that I would be just, I would be fair, and I would be honest. And to do those things, that means that I could not break the law. But the day that we remain silent about what means so much to us, in order to change the law, we have heard what you have to do if you so strongly believe in this proposition. You've got to rally your representatives, your senators, your governor. You've got to start with changing a law. As a nurse, I know the side effects of marijuana and what happens. I want no child or an adult or any person to ever have to adhere because of a lack of information. It was nothing wrong with the vote. It was nothing wrong with you wanting that proposition because of the facts that you see. When I have to go into a prison or into a jail, as a mother, it breaks my heart. And then when I hear the story of how different that our laws have to match our crimes, it is nothing wrong with your voice on Proposition A about letting the law match the crime. However, the problem is that it's illegal. And you've got to take those desires, if you so desire those things, and you have to follow those steps and to change it. I get it. I get it as a mother. I get it as a public servant. I get it as a nurse. I get it.
Your time is up.
That quick?
Yes, ma'am.
Happy Thanksgiving.
Yes. Thank you. Any other council member Sagara?
Yes, ma'am. Thank you. Can you hear me okay?
Yes, sir. You have 3 minutes.
First, I just want to say thank you to the chief for explaining that. To say I was a little bit irked would probably be an understatement, because I understand that the voters voted, but I know that there was a special order issued a couple of days after, and I had listened to our police department and the chief prior to this, and I know that, just like you said earlier, it's something that the police do not support, and so I was out there telling everybody as to the reasons why I was not in favor of it, and I felt that having a special order right after the election, before the council even canvassed the votes, was a big concern to me. And so I think that we should have at least waited until after the votes were canvassed to decide on which way we want to go. And it's proven right here, as our Mayor Pro Tem has made a motion to just continue what's been happening for the last couple of weeks. It's hard to pull this back once it's out there. If we do table it, all that basically means is that we are approving it as is, because the ordinance does call for us to come back in 3 months. My big issue really hasn't even been the marijuana part. I understand that's the part that the voters feel that we need to change, but that's not the part that has really made me go against it. It's the section 22-83, which is what we've already talked about, the prohibition against city police using the odor of marijuana or hemp as probable cause. Out of the 1,800 from the list that I've gotten, and you guys seen that I published it out in social media, out of the 1,800 arrests that were made, a lot of them were more serious crimes. And I think that the number one concern for our voters, for our citizens, has always been crime. And we, even as a council, started a crime committee. And then we're just going against that and saying, if you do commit a crime, we're taking this tool away from our police officers. So I'm more in favor if we have to do this as amending it and removing that one section. And that is my big concern, just amend it and take it. I know that our city attorney says if we amend it, it is like approving going against the state. But I just don't want to remove that tool from our police officers for them to be able to do the bigger job of crime reduction,
Sir,
which
your
is the
time
number
is
one.
up.
Thank you, Mayor.
Madam City Attorney, back to my question. With the motion that's on the floor, motion of direction on the floor, that we would come back in 3 months and discuss this item. My question is the ordinance as is in place until 3 months?
Yes, unless you repeal or amend it, the ordinances will be in place as it's worded now.
Thank you. Going back to you, Chief Campbell, with the motion of direction that's on the floor, the memo that you sent out to your officers, will that go into place until the next 3 months? Will it still be in place until 3 months if we change it or not?
If the ordinance is still in effect, if the ordinance is still in effect, then to prevent confusion and to go against why I did it, one of the reasons is the will of the voters, then that order will stay in place.
Okay, thank you. Any more discussion before we vote on it?
I have to preference that I do have a boss, unless my boss says
Yes.
otherwise. I just
Mr. Cagle?
No.
I'm not trying to put him on the spot.
No,
but I
there's
do
no
have a
problem.
boss.
We discussed this. Just to clarify one more time, the council did not pass an ordinance tonight. The voters passed it. All
Correct.
you did was say the results of the election were true and correct.
Correct.
And so now this problem has been laid in your laps, in my lap, in the chief's lap, and all the way down to officers on the street. We have 2 laws that have some conflicts in them. And so I guess the main thing I wanted to get across was you didn't pass any ordinance tonight. It was passed by the voters. And I understand the arguments on both sides. Voters spoke loud and clear, and we have some conflicts in state law.
Correct. But I want to make myself clear also. Tonight, we do have 3 options. And if we choose whatever option we choose, I understand that the voters voted on it, and we're listening to the people, but we still have 3 options. Councilwoman Gonzalez.
So I have a question, 2 parts with regards to Councilman Segarra's recommendation on amendment. We've received a lot of information this evening, and we're still receiving information as it relates to this. I do think that we need to do our due diligence to make sure that we understand the ramifications for those unintended consequences, as I mentioned, so that we're making a very informed decision for our constituents, but then also for our law enforcement officers. Mayor Pro Tem, you recommended 3 months, but the recommendation, we were asking if we felt that the 6th of December was proposed by Councilman Adams to bring it back, so that way we can take Councilman Segarra's information and the information we've received and go from there and make a determination at that
Is
point.
that an amendment to the motion?
Yes, ma'am. I would like to make an amendment to change that date to December 6th to allow us the opportunity to take in all this information and make a final determination.
We have an amendment to the motion of direction by Councilwoman Gonzalez, a second by Councilmember Adams. Any more discussion on the amendment? Okay, I'm going to go Mayor Pro Tem, and I come back to you. You'll be last. You can go ahead on, Mayor Pro Tem. It's your time.
No, I agree with 100% with what the city manager said, and I've been saying that as people have reached out to us, and I know that we're an easy target as we sit up here and say, hey, look, you did this, but we really did go by, if you spent more than one city council meeting here, you will understand that we all unanimously sat here and understood what our lawyer said and said that we're not supposed to pass this. So we didn't. It went back to the people. The people passed it. And my thing is this. I agree with also with what Councilwoman Gonzalez said as far as maybe we move it to December 6th. But the adjudication of laws is not, no one up here is an attorney except one person. And I know you play one on TV, but you're not. It's just an opinion. You may feel strongly about this opinion, but that's the guy I look to for expert opinion on policing. That's the guy I look to for expert on how to run a city. And that's who I look to for legal advice as far as the city is concerned. When we have a judge, when we have someone to adjudicate what our state laws say, there are actual people who do that. They're called judges. And they sit at the state Supreme Court and they say, they do the same thing as the federal government would say against our Constitution and whether or not it's legal or not. What we did right now was just canvass and just say, hey, look, this is what you voted on. It's an ordinance now. So I think we're doing our due diligence now to go back and make it a practical implementation of the said ordinance by December 6th. So thank you again.
Councilwoman Gonzalez,
I just have a question for the attorney. What does that mean if we wait until December the 6th? The people have voted. We're waiting. We're going into meetings to look at this proposition. In the meantime, I'm driving in my car and I have 10 ounces of marijuana and I get stopped, but I'm waiting for the council until December the 6th. Is that what you're saying? Is that what this means?
Yeah, like, until council repeals or revises the ordinance is an ordinance of the city of Killeen. So it would be in effect.
10 ounces.
Okay.
I'm sorry, did I hear? It's okay.
They were talking to each other. Councilwoman Gonzalez.
And Chief, you already issued a statement with how that's going to be handled in the interim. Is that correct?
Yes, we're doing it right now. So,
right.
And,
okay. Just want to make sure.
Just trying to be fair. This kind of saw maybe this may be coming. So we're already doing it. So there's no change to our current operations.
Yes, sir.
Can I get some clarification?
Yes, sir, from the city attorney. When Councilwoman Gonzalez finish, you can. Ma'am, you have the floor.
Thank you. Chief, just for clarity on the amendment that Councilman Segarra proposed makes perfect sense. A question regarding the 4 ounces of marijuana. What's the felony offense is over 4 ounces?
Yes,
is that
ma'am.
Correct?
Yes, ma'am.
And so typically if someone were carrying 4 ounces, is that a level of marijuana that the average person would use to smoke, or is this more than that that would fall?
The law, if you are in possession of more than 4 ounces of marijuana, then that raises to a higher level of misdemeanor and or felony, depending if we can make a case for distribution or not.
Sure. And so in this case, then, if you were to pull someone over who had marijuana, what happens then?
Sure. If under our current ordinance. So under our current ordinance, if we come into contact with someone who is in possession of 4 ounces, let's say our typical traffic stop, like Ms. Councilwoman Cobb laid out. She may be late to council. She gets pulled over for speeding in plain view. She has 10 ounces of marijuana. Well, let's say 3 ounces for the sake of this argument. And what we would do is confiscate that marijuana, and we will put it in evidence, and there will be no charges. So that's under our current, the way it sits right now.
And so just for clarity for myself, under this, as this ordinance is, and so if you confiscate that marijuana, you will file a report, I'm assuming?
Mm-hmm. Yes, ma'am.
Is it possible that the county can still, in fact, pick that up and charge these?
There is the possibility that the county attorney and their investigators may come to the police station and find those persons who are in possession, and that you could be held accountable for that.
So despite what we have on the books. Okay, and so then I just wanted to get clarity, because again, I'm not clear, just for my purposes. You said before that we are already not really enforcing the lower level offenses unless it leads to something else, right? So you guys are already using your discretion in that respect. this ordinance, if I'm understanding what the people are asking for, is to not be charged for low-level marijuana offenses at the end of the day, ultimately.
Mm-hmm.
What is the difference in us saying that there's an internal policy versus going through all of this for an ordinance that is clearly in conflict with the law? Why wouldn't we just implement an internal policy?
You're absolutely right. I will say this, that, you know, when it comes to enforcement of marijuana offenses, our department does a great job already of using their discretion. There are very few arrests or cases brought to court for people who have small amounts of marijuana. The cases that we bring to court most times have another charge attached to it, but mainly drugs. When you look at the crime in Killeen, drugs and weapons go together. And that's how, taking away that ability to search doesn't give me the ability to find the stolen property. We got people breaking into vape shops right now. I can't get that evidence because now I can't search. I can't get that illegal weapon off the street because now I'm prohibited from searching. But can we still use our discretion to enforce low-level cases of marijuana? We do that all the time. We do it now. If you are under 18, I heard talk about children. This ordinance has nothing to do with children. We will still do what we do when it comes to children. We refer them to the juvenile justice system, or we just take them home. I mean, that's what we do. If we pull you over and you have a somewhat clean record, you're not on probation, you're not on parole, you're not a registered sex offender, and you have marijuana, we will use our discretion to dispose of the case. But not having the ability to search and seize is a big deal.
Thank you.
Councilmember Segarra.
All right, thank you, Mayor, and thank you, Chief, for saying that, because again, this is my big concern, and my big concern is crime, and I just want to keep re-emphasizing that because I think that citizens of Killeen, that's what they want. They want our crime to be lowered, and by adding that section 22-83 to this, it ties our police officers' hand. And just like as the chief said, you know, out of the 1,800 marijuana incidents police found, 97 of them, from the report that I was given, were possessions of firearms by felons. 183 of them had outstanding arrest warrants, 269 of them unlawful carrying of weapons, and 621 of them had illegal drug types other than marijuana. And by adding this, all these people, close to 1,000 people, and this is just a small time frame there, would be put out on the street. And so with that said, I don't know if I can offer, because I'm okay extended. I'm okay with our Mayor Pro Tem and his amendment and all that, but I don't want to see our crime rate increase during that period. And I would offer a second amendment to remove section 22-83 from Proposition A.
Can we get a second to the second amendment to remove, what did you say, Councilmember Segarra?
Section 22-83.
Can I get a second to the second amendment?
I'll second that.
Councilmember Alvarez. All right. Councilmember, anything else, Councilmember Segarra?
No, thank you.
Ma'am, can he make that second motion to the first amendment, or do we have to vote on the first amendment?
You can amend an amendment.
Right.
And then but you would need to vote on the amendment
Yes,
to the
ma'am.
amendment and then
And
vote
the
on the
amendment,
original motion.
yeah.
I don't think the buttons are working, but I did have a clarification
Yes,
if I could. I know Councilmember Gonzalez asked made the distinction between an ordinance and the policy, and so I just wanted to clarify that I completely agree that Chief Law Enforcement has discretion and can prioritize certain things, but the statute that we were discussing actually says you may not adopt a policy under which the entity will fully enforce the ordinance, fully enforce the statutes. So.
Thank you, ma'am, for that clarity. Councilmember Segarra, are you finished?
Yes, thank you, ma'am.
All right.
Yeah, thanks. I
Councilmember
just want
Adams.
to have another clarity. So officers can still pull over and drive, whether there's a smell or not. You can still pull over for, in your discretion of driving under influence, swerving or whatever else. But does the ordinance stop from whether you got 4 ounces or not, but because you had imbibed and it may have caused you to drive that way, does this prevent that from still being?
Sure, it's a great question, sir. I think that as we talk, of course we talk a lot about this, that, we still have to collect evidence of driving while impaired. So if someone's under arrest for driving while impaired, we still have the ability to search based on driving while impaired, not on possession of marijuana. So that those things don't go away. So, and we still, when your car is impounded, we have to do an inventory search. So we still have those things to do. I think our Killeen Police Departments the officers are very bright, young men and women, and we will enforce the law. And of course, if things are in obvious plain view, then we can't ignore when we see an illegal substance, and we will seize that now. And and then depending on where we're at with the ordinance, depending on what you vote on, that depends how that goes. If it's under 4 ounces, we'll seize, we'll do a report. If it's over 4 ounces, we'll arrest and put it in the court system accordingly. If discretion needs to be done for lesser amounts, first-time offenders, there's a lot of things, again, on that scale of criminality, and it's hard to go through every possible scenario, but I trust the men and women of Killeen Police Department will do the right thing.
Yeah, that was the point of my question. It's not the be-all, end-all.
No. Police work will still get done.
Yeah.
Yes, sir.
Thank you.
Councilwoman Cobb.
Sir, I have a quick question.
Yes, ma'am.
The spotlight is on this proposition. Folks are out there, they're looking, they're watching television, and they're listening to what we're saying in this room. And just as they're listening, those persons who can make the judgment, once you let a person go and you do these reports and they go back, do you think the tendency now will be greater for people to want to overlook those reports?
Ma'am,
and someone else go to, I know it's a hypothetical question, but I can just feel it in my bones.
Yeah, it will be hard to provide an answer to that. I just think we see the way we see where things are going. Yeah. When you look at states, literally states like Colorado and Washington and New York City and Chicago, there's a trend. And I think that one of the things that we're doing in Killeen is that we are preparing for what may come next. So we are very good at what we do. We will continue to get those that violate the law, particularly those dangerous people that prey upon our citizens, whether they have marijuana a lot or not. We're still going to do our jobs, but it's kind of hard to read that crystal ball and find out. But we're just going to stay prepared, and that's the best thing. That's about really the best thing I can give you.
That's exactly what I wanted to hear, that you were going to do the best that you know how to do. And once we give it our best and follow the rules and follow the law, there is nothing that we can ask of any man, woman, or child, is that we do our best and follow the law. That's
Councilmember Alvarez.
I guess a question for our city attorney. I seconded the motion that Councilmember Segarra made to remove section 2283. I don't know if that makes more sense, or if it's an option to, I know we want to bring this back maybe December 6th. If we do that, and just, could we do a moratorium on this ordinance until then, to where it's not in effect until we reconvene on December 6th and make a final decision, instead of just trying to piecemeal something together in a rush?
I believe you could do a moratorium on the ordinance. And just to clarify, on the removal of 2683, that would have to be done by ordinance, so we would be bringing that back to you on December 6th then as an ordinance for you to approve that revision, if that's what the council is wanting to do, because that removal would have to be done by ordinance. The moratorium on the ordinance, you could do that.
And if you're thinking about doing a Fourth Amendment, You better have Councilmember Sagara rescind his, and you rescind yours, and you put it in that Third Amendment, because we're not moving on the Fourth Amendment. Do you want it to, I can talk that out, you and him, he's up there?
You only got two.
Well, we have three. We have the motion, we have the amendment, and then we have the Second Amendment, so that will be the Third Amendment. So all of them have to rescind to get to you. So Councilmember Alvarez, you and Sagara, do y'all want to change that?
No, I tell you what, I'll
Sir,
just rescind
I
it.
have the floor, please. They have to rescind theirs before it can get back to you. Give me one moment. Do you want to?
Are you okay with that, or thoughts, Councilmember Cigar?
What was the motion again?
To bring the ordinance back on December 6th, allow us time to, I guess, to further look into all the options and make an informed decision on this. But in the meantime, there'd be a moratorium, so the ordinance would not be in effect until we come back and make a final decision on it.
On December 6th.
Would that require the special order to be pulled?
The ordinance wouldn't be in play until after we meet in December 6th, if this motion that amendment is made.
Yeah. And again, my thing is, I don't want to take a tool away from our police department that they use. And, you can't say you're for lowering crime and you take this away. And so as long as they're able to do what they've been doing as far as cracking down on all these other criminals out in our streets, then I'm okay with it.
One suggestion, maybe you just vote on your amendments and get down, and then back to the original motion. Whether it passes or fails, then separately make another motion on a moratorium.
Well, is that what you want to? I don't want to tell you what to do, because in between what you said and we get to the motion may pass. So I don't want to be the one to try to tell a council member, you or Cigar, what to do. So it's up to you. You going to amendment, or we going the way we are? Okay.
Either way, it's coming back on the 6th, right? If we accept this amendment that I've made, whichever way it's coming back, right?
Okay, so we're going back to the Second Amendment, and we're going to, any more discussion before we vote on this motion of direction?
Yes.
Right, yes.
I don't understand what's going on now.
Yes.
Because.
The Second Amendment is to remove 22-.
Let me finish talking. So what I'm saying is that if we're doing a moratorium, once it's in effect right now, right?
It's in effect now until you do something different.
So what we're doing is doing a motion of direction to ultimately do a moratorium to hold up the activation of what's already in effect.
No, sir, they didn't agree to it. It's the original one, remove 22-83. They didn't agree to it.
So you don't want to do the moratorium?
No, they didn't agree to it. Did he agree or not?
Councilmember Cigar agreed, but he did not change his amended motion.
So it stayed the way it was.
No, I didn't. I wasn't clear on it. If a moratorium, from my understanding, the Prop A goes into effect, right?
No,
if we do a moratorium and it does not go in effect from today on, then I'm okay with it. And that's where I don't think I got clear on it.
Okay, so you're right, correct, sir, that if you change it, it would not go into effect today. It would be discussed on December 6th, and after December 6th, whatever the council agree upon, that's how the ordinance would be.
And you're talking about Prop A would not go into effect, even though we certified the votes.
Yes, sir.
If that's the case, then I would withdraw my amendment and let Mr. Alvarez make his.
You rescind your second? Okay, your time, sir. Mr. Alvarez?
I would move to amend the original motion to bring discussion for Proposition A back on December 6th, and in the meantime, provide a moratorium for the implementation of Proposition A.
And I would second that.
All right, that's the Second Amendment. No more discussion? All in favor, repeat what you said on the Second Amendment, the motion. That's your amendment. All in favor, repeat it, Mr. Alvarez, so they have a clear understanding.
I believe it was to add a moratorium until our next meeting, which is December 6th, on the item to the previous motion.
Thank you, sir. All in favor, yes. Raise your hand. 1, 2, 3, 4, 5. 5 to 1 on that second amendment. Now we go on to the first amendment, which was made by sir. He had the original motion. You made, yeah. You want to rescind it?
For December 6th, no, ma'am.
Okay. You just want the date. Will you repeat your amendment, please?
So my amendment was to bring this back for review on December the 6th.
Okay. And it was second by Mayor Pro Tem. All in favor, yes. All opposed, no. Yes. All in favor, yes, to bring it back on December 6th. 1, 2, 3, 4, 5, 6 to 0. The original motion, Councilmember Wilkerson.
Well,
Yes, ma'am.
the original motion was 3 months, but you've amended that motion.
So we
to
can
be
move forward.
Well,
All right.
you can vote just on the motion as amended, coming back December 6th with the moratorium
All right.
until that date.
All in favor, yes. 1, 2, 3. Will you repeat that, ma'am? Because we already voted on the date.
This is why I was asking the separation of the two, because there are two issues that we're talking about. One's a moratorium, and one's bringing it back to discuss for future agenda item. When you blend the two, I'm not going to vote for moratorium, but I do want to talk about it on December 6th. That's why I was asking to split the two up and have the vote on the motion to bring it back, and then have it, if you want to talk about a moratorium after, you can have that vote too. But when you blend the two, you put a council member in a place where they're voting for two different things.
On December 6th, we will be having a discussion.
You're also voting right now to have a moratorium until December 6th. I'm not in favor of that.
Okay. Well, that's been passed by the council, so we're going back to the original motion. And what was your recommendation, ma'am?
No, I'm just saying you had an original motion that then was amended to come back on December 6th rather than 3 months. You had a second amendment that in addition to coming back on December 6th, there would be a moratorium until that date on enforcement of the ordinance, and that passed. And you did vote against it, that's in the record, but the amendment passed, and so now the council will be voting on the amended motion with both of those amendments.
With both of them together. All in favor, yes. All opposed, no. 1, 2, 3, 4, 5, 6. 6 to 0. Can I get a motion to adjourn?
I move to adjourn.
All in favor? Meeting adjourned. What is